check. Is it working now? Hi! My microphone actually works. It's a really good thing to check your mic before you go live. That's always smart. Mom, I sent you a text message. If you didn't see it, I don't know what to say. I'm sorry. I was working on getting everything set up. I really mess this timer up every time. Every time I mess it up. It's so bad off right now. It's so bad off. Good morning, good brunch time, good afternoon, everybody. We are getting ready to fire things up. We've got a long one this morning. We're going to just get things started as soon as 11 o'clock comes running around here, which is just in a couple of seconds. And we're going to start off with some Stevens. We're going to move into some Boyd, and we're going to finish off with Fleischer, so everybody knows what we're looking at this morning. I'll do a little bit of this action. I'll say good morning. Hello, everybody. It's really good to see you. I'm your Lone Wolf Usul. I'm your curator. I'm your host. I'm the guy who put all this stuff together. It's been quite a job. We got it done. These are some good clips. We're just going to get right into them. I hope everybody enjoys what I've put together this morning. And let's get to watching some Steven. This is a pretty rough one, but I think it's a pretty important one, and it's really interesting. So let's dig in, shall we?
Eight cases, correct? Everybody?
Yes, sir.
It's called or are called. Eight cases are called, but I've got cause number 21-37686. Refresh my memory. Did the defendant plead guilty to one case?
Yes, sir. And the rest
And
will be dismissed.
All seven others are to be dismissed today.
Yes, sir.
Everybody, save for 21-37868. And 37868 and the other all other cases, which are 22-40125, 22-40124, 21-37872, 21-37871, 21-37870, 21-37869, and finally 21-37868 are all called the state of Texas versus Kendrick Bailey, and that is you, sir.
Yes, sir.
All right, you're present with Ms. Manfredi, Mr. Lane. You have pleaded guilty earlier in this case in cause number 21-37868, which is the last case in this order on the docket. And this is the first degree felony of injury to a child.
Not one is what we refer to.
What'd you say?
Just count one is what we're proceeding. What we're proceeding. with.
Which is what?
The injury to a child first degree felony.
It's charged in
Hold on.
alternates.
Okay. All right. So in summary, Mr. Bailey has earlier entered a plea in indictment, the first paragraph and the second paragraph entitled paragraph 1, together constituting a single count of the first degree felony of injury to a child, in summary, on or about November 13th, 2019 in Jefferson County, Texas. It is alleged, for which you have pleaded guilty to, that you intentionally and knowingly caused serious bodily injury to a child not older than 14 years of age. Do you understand, and are you reconfirming that is indeed what you have earlier pleaded guilty to, sir?
Yes, sir.
And of course, we talked about it. That was a first degree felony. Can I get the pad and pull that up to make sure that all of that was done in order? Thanks. So this is a regular first degree felony punishment of no less than 5 nor more than 99 years confinement or life imprisonment and a fine up to $10,000, correct?
Correct.
An agreement was reached in this case, and it looks like this was on 6/24.
Yes, sir.
An agreement has been reached in this case where whatever sentence shall not exceed a cap of 25 years imprisonment. So, is regular probation an option in this case? Everybody agrees it's not, correct? Because of the nature of the charge. So,
Deferred probation is.
okay, what else was I going to say?
I know exactly what you're going to say.
Yeah, but you're right. You can, first of all, you could be found guilty and sentenced to no less than 5 nor more than 25 years imprisonment.
Yes, sir.
The other option I think that's only available is you could, any finding of guilt can be deferred by me. You could be placed on deferred or unadjudicated probation for up to 10 years in length. There is no fine attached to this, I guess. And from the state, you can see I highlight all this stuff, but I wanted to ask you, is there any restitution here?
No,
It would
sir.
seem like there would be, but I don't see any hint of it.
None that I would characterize as calculable.
A pre-sentence report has, while we're waiting, a pre-sentence report has been prepared by the probation office for Jefferson County. Have the parties had an opportunity to review it? And are there any objections or changes to it? State, and then I'm sure the defense may have some things. Anything from the state?
Judge, no objections or changes, but I would like to supplement it with some photographs of the injuries involved. I've got
Have you
17.
Have you
Yes, but-
tendered those to the defense?
I've seen, whatever he's got, I'm sure I've seen already, but through all the discovery and when we were preparing for trial. I would say, before he tenders those or the judge accepts them, that the pre-sentence report is riddled with all sorts of extraneous offense information.
We'll talk about it.
And I would ask that, well, those pictures also refer to extraneous offense information. I would ask the court to not include extraneous offense information in determining his sentence for this.
But is that information wrapped up and relevant to the crime for which he has pleaded guilty to?
Well, I guess if we were in trial, it would have all, maybe, most of it would have been able to be admissible in certain parts
I think
of it.
at the time of sentencing, isn't it pretty, as long as it's relevant and reliable, it's admissible because it goes toward what the analysis of determining a sentence is in any criminal case, and that is criminal history and the circumstances of the crime and the relevant matters that directly relate to the character of the defendant. It's global. It's always been global. As long as it's relevant and reliable, and everything is relevant when the court is setting a determination of what the punishment should be.
And Judge, I'll note that the PSI, when they're referring to extraneous offense information, it's pertaining to extraneous offense information involving the same child. The PSI does not have other extraneous involving other children, which I did.
Well, hold on. That's not, again, well, I may have interrupted you there, but it really doesn't matter. It's important for the child, but in this case, it's got to be something that was directly attributed to his actions.
Right. And then that's what I mean is his actions involving the same
Because
child.
if the child's harmed by somebody else,
No.
I'm
That's
not
what we're-
punishing him for that.
That's not what we're referring to, Judge.
And and I guess, no, I would like to, I know that we're at the very beginning of this hearing, Judge, and what I want to preface this hearing with is, as I'm here advocating for him, for Mr. Bailey on this sentencing, he doesn't feed me my words and he doesn't tell me what to say. And so the things that I may say or bring up are not intended in any way to have the court want to believe that Mr. Bailey is not taking responsibility for what he pled guilty to, which he pled guilty to injuring the abdomen of this child, and it caused some intestinal swelling. And that at the time, it was apparently it rose to the level of serious bodily injury. There are all these other allegations that are made that were not litigated and that are going to be dismissed. And those are the things that I'm,
Point those
pointing
out. If they're included in the pre-sentence report,
Yes.
and he didn't plead guilty to that, unless the state is going to independently produce evidence to show them beyond a reasonable doubt, then I'm not going to consider them.
And so that's also going to go to some of these photographs that are about other allegations that he's been indicted for that are going to be dismissed.
Has to be proven to me beyond a reasonable doubt. The pre-sentence report has been prepared. The parties had an opportunity to review it.
Yeah.
Are there any changes or corrections, first of all, from the state?
I have 17 photo exhibits, representative photo exhibits that we're asking to supplement the PSI.
All right, but any corrections or changes to this paperwork?
No, sir.
We'll deal with that in a little bit.
Okay, Your Honor. On the first page of the pre-sentence report of the police court version, what is being reflected throughout is basically, I believe, an interpretation of and some absolute recitations of what's found in the reports and everything that ultimately may or may not have been exactly accurate. I don't see that would be something I would object to at that version. For example, down at the bottom, there's the last sentence, next to the last sentence, Bailey continued to live in the apartment. That is also mentioned later on in the pre-sentence report, and I would suggest that having that in this portion of the pre-sentence report is just reflecting the reports that were in the case, but I will be addressing that is not correct in the body of this pre-sentence report, that he did not live there. Okay, so that to me would be an incorrect statement.
Okay.
But at that point, it's just based on the records at that point. Again, in the first page, in the first paragraph, it mentions there were suggestions based upon the blood work that there were suggesting liver failure and signs of pancreatic failure. He's here on an abdomen issue, and it also turns out that in the medical reports, it was determined that there was no failure, no indication of failure of any organs. So although that was in the original reports, it is later determined in the medical reports that was not a correct finding at the time, or comment at the time. Different people were making that comment, but it's not supported in the records. But the fear of it was, but the ultimate results it is not. Again, in the police court version, it's riddled with extraneous offense information that's not been litigated and is going to be dismissed. And I would ask the court to disregard anything other than his injury to the child's abdomen, which is what he has pled guilty to and is part of this plea agreement. Defendant's version. I would move to the juvenile court history. It's not so much an objection, but it is a little bit of clarification. I went over that with Mr. Bailey on page 3. And those things that occurred in 2008 and 2009, the first two listed there for the possessions of a controlled substance and dangerous drug. He's a little confused about, back then he was 15. How old are you now? 31, who was 15, and he is not challenging the information, but he's just a little fuzzy on exactly what he was on the probation for. He just knows that he did get in trouble in Harris County. He did his probation in Jefferson County. That's the main thing that he remembers from that. So he's not saying that it's not true. He just didn't remember being on more than one probation, but he's not saying he wasn't. It's just not real clear on it. And then and as far as the deferred prosecutions, he's not objecting to those. He knows he did get in trouble in Harris County on that last entry as a juvenile for evading detention, but he came back to Jefferson County. He was told to leave Harris County basically, and he doesn't remember having to serve anything or do anything special under that deferred prosecution, but he's not saying it didn't exist. On page 5 at the bottom, it discusses a CPS safety plan, explicitly prohibiting his contact with the children. The CPS safety plan did prohibit his contact with the children, but it was a plan that was only made with Jennifer Lopez. He was not a party to that. They didn't discuss it with him. He didn't sign anything. He's never served with anything. It was a plan that she agreed to, but he is nowhere a party to that. And you'll see represented several times how he blatantly just refused to follow the orders under this plan, but he was under no orders in that plan and was not even a party to the agreement of that plan. So there would be objections to that, those comments that talk about how he disregarded his legal restrictions when he was under none. And on page 6, again, it discusses that he continued to reside with Ms. Lopez at her apartment in spite of the orders under the CPS safety plan. She allowed him to live there. He was not residing there. In fact, at that time, that month, during that month or so before this event that he pled guilty to, he lived technically at his grandmother's, but he flip-flopped back and forth between his girlfriends, one being Jennifer Lopez, I guess you would call her co-defendant. She's charged with some matters associated with this, the mother of the child, and also another lady named Rashonda. So sometimes he would stay at Jennifer's, sometimes maybe a couple of nights in a row, but he would stay at Rashonda's more than that because they worked right next to each other and would ride together. So to say he lived in that house with those children is not correct, and we're moving to correct that as not being the truth. But more often than not, he was at Rashonda's, but he did stay at Jennifer's. And if both of those ladies were mad at him, he stayed at his house where he basically lived with his grandmother's. Again, in number 6, he's stating, on page 6, the third paragraph, non-compliance with legal orders, if that's referring to the CPS order, he was not under that order himself as a party to the order. And I believe those were the things that I wanted to correct as misleading information at this time. And like I said, there's a lot of information about other things that are being dismissed basically. And if I have missed one, I would request the opportunity to correct that and add that objection when the time arises.
Anything to say in response?
No, Judge. I do agree that he was not a party to the CPS safety plan. The safety plan was in place as a result of injuries that he caused to the child, but he has not pled guilty to those.
Okay, then the court will not consider those issues that were brought up by the defense.
That being said, Judge, it's undisputed that there was a CPS safety plan in place.
Okay. That's fact. And what else?
It was a result of injuries that were alleged to have been committed by Mr. Bailey in Kevin Lane's case. That ends in 6-0, 2019, I believe. 19-33660. After that event, which was going to be dismissed, the safety plan was put in place, but he was not party to that order, or even consulted in the order.
What else? Anything else?
No, sir. Other than the supplemental photos, if the court wants to consider them.
Well, submit them. And then
17th.
November
November.
13th. This one?
Everything is November after that.
This is November?
No, that's his case.
I know what it is. I'm just asking for the dates of these photographs. All of these are this date or this date? The ones,
All of those are
the
November.
rest of these are November?
Yeah,
Okay.
yeah.
that just supposed to be a closer up of that, or
Yes.
9 and 10 are the same?
I tried to pick a couple of representative samples from each group.
Just as repetitious as all. And 2 of them, 1, 2, and 3, because they're not related to this offense that he is pled guilty to. And the other numbers that I objected to just because of repetition.
What are the numbers again? I had 1, 2, 3. You said 10 and 11. What else?
I'll have to look. 14 and 16.
What's your response say?
Judge, as you will note in the PSI,
What's the response say?
as you will note in the PSI, the
You don't
Prior-
agree with her?
no,
Okay.
the prior incident involving this defendant and this same young child were part of the investigation by the police in November of 2019. So while I understand why the court is limiting how it would consider that evidence, it is still information that was a part of this exact investigation, and also how the Port Arthur police eventually linked this defendant to the injuries caused to this
What
child.
was the other day you said?
September of 2019.
Yeah.
And
About
it's
6 weeks before.
yes, sir. And it's already agreed that there was a CPS safety plan in place. It was all as a result of that prior incident. So while I understand that the court is not considering a plea of guilt, an admission of guilt in that prior offense, it is still part of the investigation, and that's why it's included in the PSI.
Okay, let me see.
And I would just add one last thing, Your Honor. On that note, the offense that is reflected in 1, 2, and 3, states 1, 2, and 3 occurs September 20th of 19. The offense that we pled guilty to is November 13th of 19. And he was indicted for that. He was not indicted on the injury to the child for the number 1, 2, and 3 until I don't have my date right here.
Okay, anything else on the objections?
I didn't look specifically at the 10 and 11, Judge. Do you have those so I can, because it sounds like they're, the objection to those is duplicate. They articulate different viewpoints of the same injuries. I tried to pick representative samples of the child's condition when he was brought into the emergency room in November of 2019. And each of these illustrates different injuries that were
Okay.
pertinent in the investigation.
All right, objections are sustained. So 1, 2, 3, 10, 11, 14, and 16 will be removed from consideration. And then that means states exhibits 4, 5, 6, 7, 8, 9, 12, 13, 15, 17 are admitted and are will be considered by the court for this hearing.
Okay.
What else?
All I had was those photos, Judge.
Any other objections from the defense?
No, Your Honor.
All right.
Yes.
Oh, okay. Anything else from the state?
No, sir.
All right, arguments,
Yes, sir. Okay.
beginning with defense, and then state can conclude. Go ahead.
So it's obvious, Your Honor, from the photographs that there are injuries to this child, and no child should be injured, and I would never say anything to want to minimize his conditions, or this fact that he underwent injury, had to undergo injuries, especially the injury at the hand of the defendant, which we know from his admission of guilt was the abdomen. It caused swelling to the intestines. what is good to know, and which is, I would have to say, maybe by God's grace, that although the child went to the hospital with this serious bodily injury to his abdomen, that by the afternoon, he had already been showing signs of improvement. In fact, there are comments in the records about this child being life flighted to Houston, which would certainly encourage a person to think that this was a continuing serious bodily injury on through the evening. But in fact, he was transported by ground transport, the kangaroo team. So he went by ground transport. So if you see comments in the report about life flighting, that is an incorrect statement. Also, there were concerns of other issues that the child was having at the time, not just the abdomen and the intestines, concerns of liver failure and pancreatic failure. And luckily, by the end of the day, blood tests or whatever other testing that had to be done resulted in a finding that there were no signs of no findings to suggest organ disruptions. So although he definitely went there with an injury that was a serious bodily injury, rose to the level of a serious bodily injury. By the grace of God, it didn't continue on and started to heal already by the end of the day. In fact, there's a note in one of the medical records where by the end of the day or in the evening, when he's in Houston at that hospital, he is seen already, let's see, sitting up, playing with Play-Doh and picking out a movie to watch. I'm not trying to minimize his injuries. I'm just trying to show that how thankful it is that they didn't, the seriousness didn't just keep on and on. He wasn't in intensive care for 3 months. There's been children injured so badly, and these injuries the injury was serious, but thank goodness it began to, he got on the mend a lot quicker. In fact, he left the hospital, no prescriptions. He didn't have to have any surgeries. And so those are things about the injury itself that I feel like are important for the court to be aware of. As I said earlier, whether or not Jennifer Lopez let Kendrick Bailey know that he wasn't supposed to be around the children, I don't have anything that reflects that. I don't even think I see I found a statement from her, but that could have been something in the records that I overlooked. But I don't remember seeing anything where she said she ever let him know that he wasn't supposed to be around the kids. But he did stay there some, and he did stay at his other girlfriends, and at some points I'm sure he stayed at his own home. But he didn't intentionally go over there just to say, well, I'm not going to follow that order. I'm just going to go wherever I want to go. That wasn't what was going on at the time.
What was going on at the time?
Apparently he was staying with his girlfriend, and they had
quite naturally he beats a child.
No, I'm not saying
I don't
that.
know what caused that.
He says in his report, he tells the court that he just got carried away with correction,
That's not what I read.
And so anyway, Your Honor,
That's not what the man says, but go ahead.
so there's also, you'll see in those photographs, and I know that the state had an intent to submit the medical records. Those photographs are somewhat indicative. You'll see that this child had injuries of various stages, bruising of various stages. He lived in a house with, I'm sorry, I lost count. I know at least 8 kids. Sometimes there were up to 11 kids and 4 adults in a 2-bedroom apartment. This poor child was the littlest, and ages ranging, well, one younger than him maybe, and ages ranging all the way up. They all played together. There are records there are statements in the guardhouse tapes.
How many people were you seeing? How many? God bless you.
At any given time, up to 4 adults and 8 or maybe sometimes 10 children. 10. And
So what's the point of that?
the point is, sometimes you can get a bruise just playing. It's not every injury on this child has been at the hand.
Wait. This is serious bodily injury.
Yes, his abdomen was.
You said a bruise, but it's serious. There's a difference between, everybody gets bruises every day.
No, I'm talking about the photographs show bruising and different things.
Let's just, some of those photographs have been excluded.
I understand.
Okay, let's talk about just the one.
You'll see on the back, they're different there, and even in the records, it mentions there were injuries of various dates and times. So not every injury this poor child had is necessarily at the hand of this defendant. But that's why I'm pointing that out to you, is because I don't want you to think he was such a monster. He was just beating this guy day in, day out, and every injury he had. In fact, that morning, two of the children told the mother that the little boy had fallen out of the truck, and when they were all scrambling out to get out to school.
Where is that? I didn't read that.
It's in the records.
It's not in there because
It's not in this.
it wasn't true, and that's why it wasn't in there.
Well, I never had anything that said it wasn't true. I only had it as though it were true. Nothing ever was given to me to indicate that it wasn't true, or I would not have repeated it as a lie.
If we're gonna talk about evidence, you're objecting.
Yes.
We're limiting things
Yes.
that are in this pre-sentence report that have been submitted by the state, which you say are outside of the scope of this matter. Well, aren't you doing the same thing right now?
Okay, I can tender the medical reports that talk about grand transport and not life flight. I can tender the
I
picking
know
out a
this is
movie.
outside information, but okay.
I have
that's
it
not in
here, and the other diagnosis is of the child at the time that he was just
All right.
taken in.
That's-
But my point is to direct the court to the injuries to the child that were the injury to the child to the abdomen, which causes intestinal swelling, was serious bodily injury. And thank goodness by the end of the day, which if I can tender these reports, he was already on the mend. And I'm hoping that the court will ultimately recognize that, it was, like I said, really, I'm sure his injuries could have been much worse and maybe not healed as fast. And that doesn't lessen them, but it might mitigate the length of sentence that the court is suggesting might sentence this man to. He would ask the court to grant probation. He's not expecting probation. He didn't even think the court would give him probation. I've never told him to expect that, but I am trying to help him maybe
Why would you say
minimize.
that?
Huh?
Why would you say that? It's an option. for the
It
court.
certainly is an
So
option.
why are you
Just
telling
because-
him that's foreclosed?
I didn't tell him it was. Did I ever tell you that there was no way you were going to get?
You just
probation?
said you said the court wouldn't. do
Not
it.
to expect it. I said not to
Why
expect it.
not?
Because this is a serious bodily injury case on a child and a 25-year cap. And I just am telling him not to get his hopes up for something that may not happen. That's no good. That's not doing him any
Every
good.
cap is a may not.
That's right. And I discussed that with him. I would point out that in the criminal history, the 2009 evading detention, it says it was a deferred prosecution under the juvenile system. And he doesn't really remember what all he might
It's
have had to
not
do with it.
that won't be considered.
But then you'll notice that the next thing is almost, let's see, 2009, almost 10 years. 9 years later, he has an assault that he is accused of. It was dismissed. And then all of these occur. So where in the pre-sentence report that it says that based upon his defendant's history of non-compliance with criminal orders, his criminal background, collectively caution against probation, we would say that the criminal history is not that egregious. And if the court were willing to grant him probation, he would ask the court to do that, to grant him probation. But that his history indicates a long-standing pattern of criminal behavior and substance abuse. He's got a couple of drug cases when he was a juvenile and a dismissed adult family assault. I don't see that necessarily there's a long-standing pattern of criminal behavior in all of these cases at one time, right in the same time period. Maybe that's what led the probation officer to use that phrase. But we would say he doesn't have necessarily a long-standing pattern of criminal behavior based upon the pre-sentence report records. And the severity and repetitive nature of the defendant's offenses, I'm not seeing that in the precinct's report based upon the records of his criminal history. Combined with his demonstrated disregard for legal and protective measures, which he was not under an order to abide by, suggests a more stringent custodial sentence might be necessary to ensure. And so we would suggest to the court that all those things that were believed to maybe be true, for example, life flighting and the seriousness that really didn't happen, we would ask the court to consider that his minimal criminal history as a juvenile and minimal criminal history as an adult, along with the suggestions that he had violated a court order which he wasn't under. That in light of all of that, we would ask the court to consider probation. And if not, I would ask the court to consider something around in the 10-year range on this case. Thank goodness he was most ill on that first day. And I think that that indicates that although serious, it wasn't an extended length of time that he was under the weight of a serious bodily injury.
What do you have to say, sir, if anything?
Just want to apologize for what had happened on that day. I take full responsibility of it.
What happened?
I just gave him a whipping. It wasn't beating. I disciplined him. I took it a little overboard. Under the drug. Because I was under the influence of marijuana.
Sir?
I was under the influence of marijuana. And I just want to apologize.
Where did the marijuana come from?
We said where it come from?
Yeah, where do you get your drugs? You don't want to answer that?
Like, you mean the person?
Yeah.
I don't know his name.
Well,
It
tell
just
me
be
how that
multiple
happens.
people
Tell me how do you get drugs?
off the streets,
How do you do that?
just ask around. I never just asked their names or nothing like that.
And drug usage was the cause of this?
I could say it played a role in it.
What else played a role?
My anger, which I got control of since I've been incarcerated. I've been learning how to cope with it.
Well, you're in a confined facility. You're in a secure facility. This isn't the free world.
There's a lot of things that go on in Jefferson County.
Unless it makes it seem as long as you're confined, you're safe to others.
I wouldn't fully say that. Because I feel as though I've become a better person. And that's why I'm asking for the opportunity with a second chance
What are you sorry about? You said you're sorry.
for the injury that I committed.
What's the injury?
For the abuse
What did you
of
do?
the child.
What did you do? How did you do this?
I whooped him with a belt and I tapped him with my hands.
Tap? You're
I didn't
calling this
punch
a
him or
tap?
nothing,
Okay. And this is true. You were under some kind of a protective order at the time. Is that right?
I
No.
didn't know nothing about that.
You did
So from my understanding, it's no,
on a previous event involving this child?
no, sir.
So there was never, do you know what we're talking about, a previous event? In
Kevin's
In
case.
Kevin Lang's case. Yeah, I
In
never
Mr.
knew
Lang's
nothing about
case?
it.
I
I
mean-
never knew nothing about a protective order. Nobody
Well-
told me nothing about a protective order.
you're familiar with what that charge is all about, though, right?
Yes, sir.
Okay. What happened to the child there? Was the child treated in the hospital or anything? I mean, the
think so.
child, you live in that household, right?
I don't stay there.
Your Honor, I
And
would,
around that time.
At that
it happened.
time. At
When that
that time.
happened, I was at work. And after that, I didn't go to her house for almost a month.
Okay, the child, it looked like had some serious injuries here on that earlier occasion, right?
Your Honor, I'm object to the court's consideration of the facts in that case, which is extraneous to the sentencing here and will be dismissed as part of the agreement if the court follows it.
Again, I will respond that the court is going through the exact same logic that Port Arthur investigators went through when they were investigating the November 2019 injury at the hospital.
Yeah, I'm curious about what notice or information or what this defendant knew from an earlier investigation that may have resulted in what happened here. But the fact of the matter is it was an indictment that was handed up, and he had to have been charged officially and arrested and booked in, and so he's aware something.
I got arrested.
What's the time period that this earlier event occurred?
September 2019,
Which
And-
was how long? 6 weeks? 8
about
weeks?
9 weeks, Judge.
And when he was arrested on this case is when the investigators started talking more about what had happened a month
Are you-
before, but he had not been arrested on that.
Are you aware of who caused those injuries on that earlier event?
No, sir.
Okay. Do you care to know?
Yes,
How
sir.
is the child related to you again?
He's not.
He's not even related to you? But you were in the household, right?
Yes, sir. I was dating his mother.
Okay. You didn't care to find out what might have caused that?
All I know is she texted me while I was at work saying he was injured. She took him to the hospital. She ain't talked to me for a month. Then in that month, she called me and told me to come over.
Okay. What else?
Sir,
Anything else you want to add?
no, sir.
Are you, may I ask him a couple questions?
Go ahead.
Since you've been in jail for this time period waiting to come to court, which I believe you were arrested on the date of the offense alleged, in 37868. So you've been in jail since November 13th of 19,
Yes, sir.
and in that time period.
So-
Hang on one second. Has he been sworn?
No.
Do you want to?
Raise your right hand. Do you solemnly swear or affirm any statements you make today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. Go ahead.
And I'm just gonna ask you this because I know you mentioned it to me when we were in our discussions that during this time period, you recognize the type of lifestyle you were living back when this occurred. And it was mostly kind of running the streets and doing whatever you wanted to do.
Yes, sir.
You worked a little bit,
Yes, sir. A lot.
and since you've been, but you didn't finish your education.
No.
And since you've been in jail, what has been your thoughts about how you would like to live the rest of your life?
I want to get my GED. I want to take the CDL classes to get my CDL. And also I want to do what's it called? Selling houses, real estate. I've been looking online, well, on the tablets we have now, I've been doing, I've been taking little courses for stocks and bonds and for the, and I'm trying to get the one for the real estate. I just found out that they got.
So regardless of what sentence you get, whether it's time in prison or it's probation, you have plans to work on the way you live your life when you get out?
To better myself.
Or while on probation or after a sentence, and
Yes, ma'am.
that's all.
State.
May I ask questions, Judge?
Yeah, you may.
The child in this case, Jeremiah Williams, you called him BJ, didn't you? Or everybody called him BJ?
That was his name.
Okay.
What does BJ stand for?
Baby J, I think. Baby Jeremiah, something like that. I just called him BJ.
He was like 4 years old.
Think so.
Who was BJ's father?
Jeremiah Williams.
Do you know Jeremiah Williams Sr.?
Yes, sir.
What's your relationship like with Jeremiah Williams Sr.?
I mean, he didn't like me. David's children's mother.
You've had a number of altercations with Jeremiah Williams Sr., haven't you?
In Jefferson County, because he spit on me.
And outside Jefferson County too?
Yes, sir.
And when you were talking about Jefferson County, you mean the jail?
Yes, sir.
And what about, did you like him, Jeremiah Williams Sr.?
I mean, I didn't have a problem with him.
Even though he didn't like you and attacked you and spit on you?
Still didn't have a problem with him.
The morning of November 13th, when you took the kids to school,
Mhm.
why did you want the truck?
Because I had something to do.
What'd you have to do?
I can't remember.
So if other witnesses had told us that you had some licks to go hit, would that be true or not true?
I don't understand the reason of that with dealing with this case.
You took all the kids to school that morning, right?
Yes, sir.
You dropped the older kids off at Travis Elementary, right?
Yes, sir.
You dropped Jeremiah off, didn't you?
Yes, sir.
But you dropped Jeremiah off 3 hours later, didn't you?
Yes, sir.
So Jeremiah didn't get to school on time.
No, sir.
What happened in those 3 hours?
We already came to the conclusion of that.
What'd you say?
We came to the conclusion of that.
Answer the
That
question.
I disciplined him.
What did he do to deserve discipline?
Just crying for no reason.
For no reason whatsoever. And where did you discipline him at? Where were you physically at?
In the truck.
So you and Jeremiah stayed at that truck for 3 hours.
No, not 3 hours. I had to drop the daughter off. Then I had to go do what I had to do. But it wasn't no 3 hours. I was disciplined. You can't discipline somebody for 3 whole hours.
Well, how long did this thing that you don't remember you had to do, how long did that take?
About an hour.
Okay. And you're saying here today that was not a drug deal.
I refuse to answer.
Move on.
And you said that you hit Jeremiah with a belt?
Yes, sir.
You never hit Jeremiah with your hand?
Yes, sir.
Did you
I
hit,
didn't punch him. I never punched him.
you never hit Jeremiah with a closed fist?
No, sir.
Did you sit on Jeremiah?
No, sir.
He's not alleged to have sat on him in this case. Speak to that.
That manner and means is causing abdominal injury.
No, sir. I never said on him.
Nothing further, Judge.
Okay, go ahead, state. Your turn.
Judge, okay, so I have a few things that I do need to correct from what was represented to you earlier. First, the kangaroo team at Medical Center, that is, or at Texas Children's, that is actually a more advanced team than Life Flight. That team includes specialized nurse practitioners, emergency medical services, and they come as an entire group of people only in specialized cases where there is either serious injury or death at risk. The kangaroo team from Texas Children had actually probably only comes to Beaumont once every couple of years. This is not something that is, oh, well, he wasn't life flighted by a helicopter. So he didn't have as serious of injuries as it appears in all the photographs, all the medical reports and everything else. This child, when he presented at the emergency center in Beaumont, he was in multiple organ failure. And that is clear by the blood levels for his liver enzymes. And as the court is aware, the injuries alleged here are abdominal intestinal swelling. That is part of the digestive system, which is also the liver, which also affects pancreatic function. That is the reason why those two organs were in failure. And I wholeheartedly disagree with the representations that this kid got on the mend later. He was at Texas Children's for 5 days. This is not something that was just an easy thing to get on the mend from. The other thing that I have a problem with is that these types of injuries are internal. And the whole issue here, Judge, is that the abdominal injuries, what you'll see in the photographs, there are injuries to this bruising to this child here and at the lower pelvic region. Those types of injuries can only be caused by severe force. Hitting someone with a hand, hitting someone with a belt is not enough force to actually cause injuries to the abdomen in that way. This was serious force. And for that, I think that he is still not being honest with the court about what he did or how it happened. And I have a very serious problem with that.
You know what?
Oh, my bad. I'm sorry.
Let him,
Yes, sir.
number one, he is entitled to speak just like you were.
Yes, sir.
Besides, interrupting like that's rude.
Yes, sir.
Go ahead, finish.
He claims he's being honest, but he won't tell us where he was on this mysterious trip that he had to go to the morning that he took all these children to the school. And I mean, that's when the injuries happen, Judge.
Anything
Judge, are we asking for as far as what our recommendations are? I think mine are clear. This is
anything else before everybody gives their final request to me. Let me, I want to clear one thing up. This previous CPS order that had been entered into at the time that the defendant committed this crime, did it order the defendant not to have any contact with children?
he was not a party to the order.
Okay.
It was Jennifer Lopez, the child's mother, that was the party to the order. So that is by virtue of her disregarding that order, that is how she has a case pending.
Says in the pre-sentence report, despite a CPS order prohibiting the defendant to have contact with children, he was living with them. That's obviously misleading.
Correct, Judge. I do agree that is not orders expressly prohibiting him. I will say that we intended to present evidence, and I don't know if it's encompassed in the reports that he knew of the order.
But the order would be prohibiting him personally. Does he know that or not?
The order prohibited her from allowing the children to be with him, but he was never made a part of the order. He was never talked to by CPS. He was never served with anything.
All right.
And never signed
All
anything.
right. That's all I need to know. But summarize, what do y'all want?
Again, Your Honor, he has been in jail for quite some time now. We're fortunate that the child's injuries, although initially serious, that he was able to overcome them even after 4 or 5 days, as the state said, that he left the hospital without even a prescription or a surgery or anything. The defendant has had plenty of time to think about his life going forward. He asked the court first, he would ask the court to consider a probation with all the regular terms or whatever terms the court felt necessary. And in the alternative, I would ask the court to consider that although 25 years is not 99 years or life, it is our cap. And I would say that even within the cap, that the court, we would ask the court to consider something around the 10-year range if probation is not appropriate.
Judge, I'm deeply disturbed by his version in the PSI. And then, in my opinion, he just made it worse today by what he has proffered to the court as far as trying to explain how all this happened. This is worth every penny of the cap of 25. I would ask for 25 years.
Anything else, Mr. Bailey, you would like to say?
No, sir.
All right. If nothing further, I'm going to find as follows. I hereby find you guilty beyond a reasonable doubt of this first-degree felony of the most disturbing type of case, one of the most disturbing types of cases, and that is intentionally and knowingly causing bodily injury to a 3.5-year-old. And hereby applying blunt force trauma to the child's abdomen area. I hereby find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 25 years. 3.5-year-old child should be thinking more about Santa Claus and fuzzy little animals and the good things of life, not having to live through the horrors of what a cold-hearted person, adult, can do to a 3.5-year-old child like you did. You took advantage of an innocent child, one of God's greatest creations and gifts to all of us, and you almost killed the child. According to the definition of serious bodily injury. That is all. We're in recess.
I've submitted dismissals, Judge.
All right.
That was a rough one, guys. And, you know, Stevens always has the rough cases. That's the reason I kind of started on his there. We're going to move on to Boyd. She generally also has some pretty rough cases, but this one's funny, interesting, still a little rough, don't get me wrong, but I think you'll like this a lot better. It'll be a palate cleanser before we get to our grand finale with Judge Fleischer. So let's check out some Boyd, shall we?
Court is calling 2024 CR 6187, State of Texas versus Michael Daniel Hernandez. And this is going to be our last case, and then we're taking our break. Could I have parties announced for the record for the state?
Daniel, that's for the state of Texas.
Defense?
Renee Munoz.
Are you Michael Daniel Hernandez? Keeping it 100?
Yes, sir.
All right. Counsel, have you received all of the discovery? Did you review it with your client?
Yes, Judge, that's correct.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney?
Yes, Judge.
Did you understand it?
Yes, I have.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yeah.
Mr. Hernandez, did you review the document entitled Court Admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with attempting to take a weapon away from a police officer? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility
Yes, sir.
and up to $10,000 fine. Did you understand?
Yes, Judge.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Right.
Court, well, are you?
Yes.
All right.
All right.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 6 months in the state jail facility. There are no applications. The state will take in consideration 2024 CR 6188. Did you understand that to be the plea? Defense, is that the plea?
That's correct, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State opportunity to the one and all practice. No objection.
Right. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it?
Yes, I did.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Yes.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes. Yes.
Anything you wish to say on behalf of your client?
We ask that the court follow the negotiated plea agreement, Judge.
All right, Mr. Hernandez,
Yes,
what is your relationship to Joe Hernandez?
that is my brother.
And how old is he?
He is
Approximately.
55,
And how old are you?
40.
And Jonathan Souza, that's the officer.
Yes.
And then who is Antonio Gonzalez? And were you and the brother living at the same location or no? And who lives there?
And my brother.
All right, why are y'all bringing foolishness to her doorstep? People always go back to their mom's house. You all are 2 adult males. And all of this starts over a weed eater.
Yes.
And then he flicks a cigarette at you. And then the officer says, he's there trying to calm everybody down. And he says that you pick up a burrito and you throw it so hard at your brother that he can hear when the burrito hits him in the eye.
Just reaction.
What was in that burrito?
Just the end of the burrito.
What do you mean the end of the
Just
burrito?
last bite, because there was nothing in it.
So you have been eating the burrito
I just cut the glass.
and then you throw it and hit him in the eye with it.
I guess it was just the reaction I got. Was he goes
Well, no, but you all are in your 50s bringing nonsense to your mom's doorstep. And I see the tattoos, so I'm sure that signifies certain things. Why are you all grown males living at your mom's home? Why don't you get your own place?
I just got out of Bible school and I just became an evangelist. It was just a wrong timing. And I was
Well-
accused of something that I didn't do.
So obviously you don't, but obviously you don't believe in turning the other cheek. You hadn't got that far in the biblical text.
It's the reaction.
Understanding that cigarette phone.
Yeah.
Ways.
I got hit with the cigarette on my face.
One at a time.
Yeah, I just literally, and not meaning to hit him in the face. It was just the reaction I got.
So with regards to this case where he hit his brother in the face with a burrito, is that still outstanding?
Dismissed, Judge. It was rejected.
So the brother, I guess, had a change of mind, because I'm sure the mom probably said, y'all are my sons, stop this foolishness.
Yes, Judge. I spoke with the brother and he didn't want to proceed with the charge, and my client knows that it was kind of a petty thing to have started, and I've talked to my client that if a situation like that arises, you get out, you go for a walk, you kind of, deal with stressors in a positive, healthy way. And he's learning that that's going to be beneficial, because I told my client if a situation like this happens in the future and the police come, they're going to see his history, they're going to see some of his tattoos, they're going to think the worst, put him in
Yeah.
custody. And he'll be in there for quite a while. So he's cognizant of that, Judge, and he's looking forward to using this as a learning experience.
All right, the court is finding you guilty. The court will sentence you to 6 months in the state jail facility, give you credit for any time served, taking consideration 2024 CR 618. You can review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record, and Maria, you can shut it down, and we will be back. Well, take your time with your lunch.
Hope you enjoy your lunch, Judge.
All right, thank you, sir. Here's the thing. Do not get into those type of arguments. I'm sure y'all break your mom's heart. Two of her sons are fighting each other. And then obviously that wasn't a good burrito, because it was, you wouldn't have thrown it. All right, good luck to you, okay? You're welcome. Oh, is that your mom? All right, Mom, don't let him stay at your house anymore. They're grown adult males. They need to do their own thing. The only thing you should be coming to your mom's house to do is mow her lawn and edge it and see if she needs help with anything. All right, good luck to you. Thank you all. Thank you.
I hope that made other people laugh as much as it made me laugh. That was a silly case. I mean, it's a serious case, don't get me wrong, because it's a felony and it's in front of Boyd, and he's doing 6 months because he tried to take a gun from a police officer. But it all happened because he threw a burrito at somebody because they were having an argument over a weed eater at their mom's house. I mean, how much more silly can it get, right? Well, we have some more silly. Well, actually, we just have some more good, because we got some Fleischer from Friday that's coming up right next. And while Fleischer was live on Friday, one of our community members, Mayor McNolm, actually stopped in and had a conversation with the judge. So I threw that in there so everybody can see that conversation too. I thought it was a pretty cool conversation. So this is a little bit of Fleischer from Friday. I hope everybody enjoys. We're going to dig right into it.
All right, Judge, next is page 11, Jones. Gerald, come on up.
You say this is Gerald Jones? Mr. Jones, do you have a lawyer today?
Okay.
Your case is 1,533 days old. I'm going to appoint you a lawyer and we figure out what happens with your case today. Take a seat for me in the jury box. Carter. Who's this?
I'm not sure.
Oh, that's right.
Mr. Baldwin for a plea, Your Honor.
Okay. Yeah, come on.
If we rank on the floor.
He's almost done.
Okay, we'll do it. It's just this is Baldwin?
Yes.
Okay.
All right.
Hi, Greg.
He was on hey Judge, he was on aggravated robbery upstairs. They filed MHJ, it was dismissed, they amended his conditions, he's gonna be going to.
Oh, you were charged with an aggravated robbery. You picked up these cases and now they've amended your conditions. Do you know how lucky you are? No. Do you know how lucky you are when you get charged with an aggravated robbery and your probation gets revoked? You're looking at 30 years.
give or take, depending on what judge you're in front of. You get a bad judge, 50 years. Close to freaking life. They will only do this so many times, Mr. Baldwin. So whatever you're doing in life, whoever you're hanging out with, whatever you're doing, do the opposite, because what you're doing now is not working. So if you get an idea to do something in your head, do the opposite. With us, you're charged with evading arrest. You're facing up to a year in jail and or a $4,000 fine. Are we doing just time served?
Yes, Your Honor, and he needs to, the court upstairs gave him 2 weeks to sign up for thinking for a change. So I told him he better do that Monday morning.
So the condition for them that they amended it was only to do thinking for a change.
Thinking for a change is right.
Yes, sir. It's easy money. There's no excuse, Mr. Baldwin. I'm going to tell you this evading arrest is going to go on your record now. It'll be there for the rest of your life. This is an enhanceable offense, meaning that you ever run from the cops again, they can use this to enhance your punishment to a felony. And then you're looking at years instead of days. Do you understand? Not only that, you pick up a new case, put your head between your legs and kiss your butt, because you're going to prison for a very long time. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no going back. Do you understand? This will be a conviction on your record. You're also, from misdemeanor court purposes, looking at a minimum of 90 days in jail for any cases you pick up in here. Do you understand?
Sorry.
How do you plead to the offense of evading arrest? I will find you guilty. Sentence you to 30 days in jail. I'll give you credit for the 26 days that you've done. Good luck, man. Make me proud.
Good morning. Thank you for change. Okay. Thank you, Judge.
Morning, Judge.
Hey, good morning.
You're on Victor Charles. It's a fugitive case.
Okay.
It's out of Alabama. I'm just approaching.
Do you want to bond too? Okay.
Judge
Amy.
State would be opposed. Has 5 bond forfeitures and 6 prior fugitive cases. He also has a false statement of property credit through.
Oh, okay, hold on a second. Hold on. Can we please, let's get him, because he's here. It's only fair that he hears this. We've dealt with Mr. Charles before, have we not?
Yes, sir. He asked me to approach.
That's okay. And look, right.
It is what it is.
Yeah. So just, sorry.
Some of those too.
So, hey, this guy needs to be with Rachel. So I don't want to reset him just yet. Okay. And then, I know. I'll get some more this weekend.
Say they never come get it.
I don't know. Yeah.
I know it's because they haven't in the past, they haven't come to get it.
Hey, Judge, I'm
Just
just.
no certainty here. Why? They've already been out here for a few minutes and he's gonna be inclined, not granted. But
Is this the one with a parent here?
I'm not sure.
Yeah.
So pretrial bond conditions?
Yeah, no, for sure. No drugs, no alcohol, no weapons. And this new bring back in 2 weeks. Yeah, but did you appoint a lawyer?
Yes, John
Yeah,
did. that.
okay, yes.
Okay, thanks.
Mr. Charles, how's jail?
Terrible.
First.
Good. I hope it's absolutely miserable. The idea is that you learn. from this.
learning.
Really? Well, so at the outset, I don't know what's going on. I don't know how many cases you have. So let's talk. All I know is that counsel is asking me to set you a bond. The only other thing I know is that you have 4 prior fugitive cases with us, right? And now you've picked up another fugitive case. And looks like you picked up another gun case as well. And you're on probation for false statement, a felony false statement. So I don't know. Let's see. Amy, enlighten us.
Yes, Judge, the state would be asking for no bond based on the fact that he's had 5 bond forfeitures. He has had a conviction here in 2022 for false statement of property credit, 30K to 150K. The charges he is wanted for out of Alabama are theft of property first degree, criminal mischief first degree, and receiving stolen property first degree, and then of course his prior fugitive cases.
Does this fugitive case have anything to do with the prior fugitive cases?
So the prior ones, he had a prior one out of Franklin, Alabama, but this one is new because they issued this after we disposed of it.
This is new.
Well, I mean, it doesn't necessarily mean it's new. It could have been like he went back, perhaps amended conditions, and then left and didn't do what he's supposed to do, so they would issue a new
It
one.
stands that they reissued a new warrant.
Right.
with a new date.
Can be used against you. So he had an issue in New Mexico. He took care of that. That case was dismissed. He had an issue in Virginia. He took care of that. That case was dismissed. He's got a job now. He's working at Powerhouse Construction. He has 2 children, a 3-month-old at home. He's got a fiance at his house. He's got support. And if he gets a bond, I'm confident he will go to Alabama and take care of it like he's done in the past with his other out-of-state cases.
Did they issue a warrant in the felony case? What's going on with that one?
So it was a 2-year deferred, and it should have been completed 5 months ago. So I was just hired yesterday evening. I do need to contact the court and see what they want to do with that.
You know, he's in the 177th, right?
Trust me, I know. But his 2 years is over. You know, I don't know if they want to unsatisfactory terminate him, but
Yeah, I
checked
don't know.
on district clerk last night, and there's no MAJ, there's nothing.
Mr. Charles, I can't. You got to understand that you got way too much baggage, you know. My concern, number 1, is public safety. Number 2, whether you're going to go back. And you have so much baggage that I can't, you know. I can't continue to give you bonds when you continue to do stuff you're not supposed to do.
Yes, sir.
I mean, you got to understand that, right?
And so just so he understands, they'll have 14 days to extradite him to Alabama.
If he waives.
He will. He's waiving.
He also has to
You
make
don't
bond
waive,
on
you're
the
just gonna
local
sit in
as well.
court forever.
Like you see that.
Oh, that's the other thing. So the other kicker is this, is once you waive, we give Alabama 14 days to come get you. And if they don't come get you within the 14 days, they file a dismissal and that hold is basically lifted.
That's what happened with Alabama.
Here.
My 3rd time sitting with them, that's why.
So
And you're gonna keep getting arrested until you go back and take care of it. If they let you out here, that Alabama warrant is still open and valid. So you will still continue to get picked up over and over and over again. Just because Harris County released you doesn't quash the warrant from Alabama.
Right, that's why.
It's still open.
I'm saying, yeah, that's why I had to deal with Virginia. I didn't have to go to the Virginia and they dismissed the warrant. 'Cause I'd never been to Virginia. I didn't have to go down there when I was getting arrested for it. And here, I never went down there. They dismissed the warrant, same
Hey,
thing.
it really, it's neither here nor there. All I'm telling you is that it's
Have to take care of it.
eternally open until you go. The other kicker here is that you have not made bond on the
I did
UCW.
it on purpose, not because I didn't want to do that.
That's
You
okay.
can accept.
So basically, if he were to waive today, it's still told, meaning the 14 days does not kick in
he pays the
until
bond.
he makes bond on the UCW.
Up to your dad.
Yeah, I would have made it, but I didn't know.
And that one's a low bond. It's at $500.
Okay, I'll talk to his dad
So-
today.
So just what I would do is waive today, stay in touch with Mr. Kim or Amy. The minute you guys post bond on that, give them a heads up so that they can contact and let Alabama know that the 14 days has started running. Because I don't want there to be an issue where somehow they don't get notice of it, and then they come and ask for an extension, right? So the quicker you let them know to let Alabama know, less time. That's it.
Got it. I'll take care of it.
Don't
Okay.
take care of Alabama, man.
Okay.
Really.
We'll talk.
Over and over and over, man. Really.
Yes, sir. Yes, sir. Okay.
Okay.
All right. Thank you, Judge. May we be excused?
Yes.
Gerald Jones, just appointed today.
Jones?
Yes, Judge.
Oh, yeah.
Mr. Jones, he's a veteran judge. He's actually, I've actually shown the prosecutor some of, he's been actually in a treatment center, getting some treatment. And he's coming all the way down from.
Has he been in a treatment center for 5 years?
No, Judge, I apparently had a previous attorney. Again, I haven't access to the case yet, so I don't know all the background information, but I'll get with that attorney, find out what information they have. Apparently it's a non-alcohol DWI case.
Come up, Mr. Jones.
That's correct.
It's a weed DWI
And PCP, Your Honor.
and PC.
Presence of
Oh,
it or actual amounts, you know? Was it-
I have numbers, but the numbers don't mean anything to me.
I drug test you now. What's going to show up, Mr. Jones?
Marijuana.
What else? I'm going to know more. I'm sending you for a drug test now. I want to know what is in your system, especially if it's PCP. If it is, we're going to have issues. I'm telling you that now. Your case is 1,533 days old, and we decide now what happens. Do you have a Texas driver license?
Yes, sir.
Can you run his license, please?
Sure.
And you drive.
And then Pavel, any prior DWIs?
Oh, I have to run it through the.
Oh,
This is
okay.
some-
Just because you have a physical copy doesn't mean anything.
Here, can I see the physical copy? The things.
But again, but you should take your bus down or you, okay, you take the bus down. I have no. Yes.
Oh.
Judge, he actually works with the VA, actually for the VA through the work therapy program and gets services through the VA, Judge.
We have an issue. Where is it?
And pending images?
Can you print it out, please, so we can give it to them?
This is DWI, Judge.
His license is eligible, Your Honor.
This is his only DWI. He has a record, but this is for DWI.
Mm-hmm.
No, I can't read it.
Oh, you can't read.
I just did.
It's an app, it's a surrender, your bonding company has filed an affidavit to surrender your bond. They don't want to stand your bond anymore. And if I grant that, you go into custody.
Judge, if you could maybe reset this for a week, and he does have to come back down to, I know, but if we could, if I could just, maybe he needs to just contact them. Again, it just seems like an address matching issue. Now, again, so before you grant this, Judge, if we can at least have a chance for him to keep in contact with them and see if it's just a paperwork filling out issue that needs to be addressed. Because we believe the defendant's,
What's the bonding company? Who is it?
he's not fled the jurisdiction, Judge, he's right here.
It's in Montgomery County.
What reason does it state there? Kevin?
Address that is provided the residence does not match the location. And he said he verbally will not be attending court, which obviously is not true, Judge. He's come down for court right now. So I don't know why, again, he might just have to talk to them.
Yeah, because I check in with them every Thursday.
I think they might have, for example, he told me, Judge.
Mr. Jones, they don't file that unless they're unhappy with you. They are unhappy with you. I am unhappy with you, and I'm going to put an ankle monitor on you now so I know where you are at all times. I'm not going to rule on that now because I'm not going to be obtuse and just put you into custody. But I'm going to tell you now, if you ever so much as walk wrong or fail to show up, I'm going to make your bond so high, you're going to turn white. Do you understand?
Yes, sir.
And Judge, would you waive fees? I am court appointed on that.
Yeah.
Thank you, Judge, for doing that. And Judge, he does live in Fayetteville, Arkansas. So he can be
No.
bust down.
No, I mean, when he goes, he doesn't come back. I don't know what to tell you, but the case is 5 years old.
Yes, Judge, I just, he doesn't, do you have any do you have any place to live here even? I mean,
I have my parents, but
I mean, we're just keeping him here. He just took a bus down from Fayetteville, Arkansas to be here.
Is
So-
discovery in?
Everything except the videos, Your Honor. I'm not sure if there were body cams in 2020. But we requested them. Everything else is in, Your Honor.
Did you make a copy? You know, well, you don't know, right? Maybe they had a physical copy. And they
Right, it might be on the VHS.
Okay, that's true. Yeah. Judge, could we also put a motion for a VHS recorder?
I'm sending you now for a drug test.
Yes, Judge.
I want you to go take a drug test. I want to know everything that's in your system, and we need to address this. So I need you to come back. I know that you live in, let me ask you this, are you working?
yes, sir. I work for the VA hospital in Fayetteville.
Okay, pick a day next week that you want to come back, but I need you to come back so we can talk about the conditions that we're going to do. I am going to put an ankle monitor. I'm not going to restrict your travel to Alabama. You can go back. I'm going to tell you now, there's absolutely, or Arkansas, wherever it is. I don't care what your excuse is. If you ever fail to appear again, I'm going to triple or quadruple your felony bond, and you will stay into custody. Do you understand?
Yes, sir.
You're not to consume alcohol or illegal drugs. If I find that you're consuming anything, because I'm now also going to put a scram on your ankle so I know that you're not consuming, I will pay for everything for you so that there's no excuse. But if you so much as do anything, take anything that you're not supposed to, it's all over. And I'm going to tell you now, if you test positive for something more, then I'm going to keep you more with me. If you're testing positive for hardcore dope,
Yes, sir.
you understand?
Yes, sir.
With mental illness, when you take something like PCP, it completely throws your brain into a haywire. And I've seen what people do on PCP, and it's absolutely nuts.
That's why I went to.
And Judge, that's why we have a letter for, he actually did inpatient residential treatment judges this year. And so, I approach our.
When is that from?
Yes, sir. He was in Desert Storm, Judge, apparently, obviously in combat Marines, Judge, so I think he's been struggling. And so we're gonna talk to his caretakers up there, Judge, and see. I'll get some of that information. I've shown that already to the prosecutor, but we'll get some more information.
Why? Do you have an open case in another jurisdiction that ordered you to do this?
No, sir. I was suicidal. I had the issues. I suffer with PTSD, and I want to help.
It's okay.
Mr. Jones, there are certain ways to, when we all have down days, right? But there's certain ways that you have to handle this, and using dope is really just going to make it so much more worse. You know, why not find a creative outlet like exercising? You know?
I was at a loss, sir. I didn't want to live. And I reached out to them and they sent me up there. I mean, it's not an excuse. That was just me. I couldn't take it, and they helped me. And
Let me ask you this. What's so bad? What happened that was so bad that would cause you?
everybody was using me. My parents gave up on me.
You said your parents gave up on you?
Yes, sir.
And are you talking about all the criminal cases that you had? Or is it, as when you say as far as everybody accusing
I've
you?
been taking care of this my daughter for 7 years, and I found out she wasn't mine, 2 DNAs, and that's when I got
So,
hooked
but that
on.
doesn't mean that she's still not yours, you know?
My mom don't want to have me nothing to do with her. And like I said, I'm not making excuses, sir. I'm trying to get past all of that. That's why I admitted myself to rehab. I went to one in San Antonio, and I got kicked out of sober living because of my anger management.
You got in a fight or what?
No, sir, someone stole something from me, and I got upset and threatened to slap the person that stole it because they wouldn't find them. And part of being in that sober living program, theft is one thing that gets you kicked out. But they didn't want to look for them. They just wanted to get me out of there for my anger issues. That's when they sent me to Fayetteville, which is a PTSD program for veterans. And that's how I ended up there. They offered me everything. I'm taking anger management classes. I'm seeing my psychiatrist. I got support groups.
That's great.
And you're actually working with them, right? I mean,
I'm
you're
working
working at the VA getting paid.
I'm doing everything to the system to help me because.
So it seems to me that things are going well now, right?
Yes, sir. And that's why I mean, and that's why I was saying when last week, they gave me 3 days, like every day, when I got arrested in July, and the 4th of July, I was coming home for our family reunion and I got pulled over. I didn't even know I had the warrant because the lawyer that I had, she was trying to tell me to go to Veterans Court because they told me there was no alcohol in my system. And for some reason, she dropped my case. I thought because she was showing up for me, I didn't hear from her. So that's why I didn't never knew.
Can't, when you're charged with a criminal case, you can't out of mind, out of sight, or out of sight, out of mind. It doesn't work like that. You have to know.
Yes, sir. I mean, that's what I'm saying. I didn't know she dropped my case until I got arrested.
I don't let people withdraw. I don't let people withdraw unless, typically what we do is we have people come in and they have to ask me to withdraw, but I always require the defendant to be here because I know that I've been in that very situation where I've signed a withdrawal and then the defendant comes back and goes, what are you talking about? I paid this lawyer. I don't know why I withdrew. So because of that, I require people to be here regardless. I will give you whatever you need to help you out, but you have to show up. You can't take off on us again.
And that's what I'm saying, sir. I didn't take off. Last week, I didn't show up because, like I said, since I got arrested, I check in every Thursday. And I asked them, when is my court date? Because I'm down there and I need time to plan for this trip. Because the buses leave at 2:00 in the morning and they get you here at 5 p.m. So I wouldn't have been able to make it to court. I had to leave a day early, 2 days early just to get up here.
Work with you.
Sir?
I will work with you to make it as easy as possible.
Yeah, I mean, and that's what I'm saying. That's probably why they was trying to turn me down at the other place because.
No, the only other advice I'm going to give you, Mr. Jones, is your record sucks. If you get pulled over and you're in a car with what kind of prior criminal history you have, what do you think an officer's going to do?
That's what they
every single time.
I had an aggravated assault, deadly weapon, no bodily harm. I was as close as you.
But what I'm trying to tell you.
Yes, sir, I understand.
No matter what the facts don't matter. Perception is reality. They're going to see all these priors. They're going to see the DWI, ag assault, evading arrest, PCS, POM, PCS, evading. They're going to see this and they're going to give you a hard time every single time. And if you have anything in your possession, when you get pulled over, you're just going to go to jail every single time because you will get searched every single time.
That's how they did me but I didn't have anything when I got arrested for the 4th.
What I'm trying to tell you is be smarter than that.
Yes, sir.
Don't have the smell of weed in your car. Don't have anything.
Judge, I meant to approach because procedurally, you're correct. You denied the motion to withdraw, so I'm not sure.
Yeah.
It was denied and then they refiled it a week later, October 20th, 2021, and it wasn't spoken for. So I'm not sure if we can assign.
I denied their motion to withdraw.
I'm not sure procedurally if we can assign anybody since they're already.
We can. In the interest of justice, I can do it.
And I'm the attorney of the day, or sorry, I'm one of the attorneys of the day, so I can.
Who was the lawyer?
Standing in.
Attached when I made the assignment.
Yeah. I mean, in the interest of justice, you can do that, Judge. I'm just saying procedurally we never,
Who was initially appointed? Did you see?
It wasn't appointed, it was hired.
Was it hired?
Stephanie Alfonso, Your Honor.
Alfonso.
Yeah, and they filed their motion twice. Once was denied and then later.
I don't, unless I know that a defendant is here and willfully refuses to come, I don't grant motions to withdraw. I don't, because I need to know that you know that or you or any other defendant, I need to know that you know that the lawyer wants to get off. So that's why I denied it. Regardless, that's neither here nor there. We need to move forward. So where do we go from here?
Judge, I'm
Mr. Stryker.
gonna get the evidence in the case. I think we're gonna double check to see if Stephanie has the videos or if it just needs to get another copy or if we're just still
Let's
getting
do
them in.
this. Let's do this.
So,
I want to make sure that you're not using. So I will send you for a drug test now. I will also order you to have a scram on one ankle so that you're not consuming alcohol. Okay. I'll forego the GPS monitor. Okay. Just my only concern is that you're not using. Okay. Now that I've had a in-depth conversation with you, I will trust you to come back. Okay. I don't think I've ever done this on a case that's 1,500 days old where I haven't put a GPS monitor. So please,
Thank you, sir. Thanks.
if you come back, good things will happen. Okay. And perhaps Mr. Stryker can get you into a veterans court, because if you can get into a veterans court, good things will happen for you.
Yes, sir.
Right.
Sir, thank you, sir.
Let's send you for a drug test. I want to get the scram on. I'll set you off for 30 days. Okay. I want to see the results. If the results come back and they're not good, we're going to have another conversation, but we'll make arrangements for that. Okay. Can we get the scram on today? I'll get it on today so that you can leave today and go back home.
Yes, sir.
Just one day at a time. That's all it takes, right? You put your leg on, you put your pants on one leg at a time, and you just take it one day at a time. You know, things will get better. If you're honest with yourself.
he just wants to get a baseline of what's in their system, right?
Yes, sir. Yes, sir.
Are you smoking weed now?
No, sir. That was yesterday after work.
Are you taking any kind of psychotropic medication?
Yes, sir. I don't know the name. It's slip blue pill, mood stabilizer.
If you're taking that and you're using anything else like weed, PCP, or any other kind of dope, it's going to throw you for haywire. It may not happen today. It may not happen tomorrow, but it will at some point. If you're taking medication for mental medication, don't use, because it will counteract what the medication is trying to do. No meat, no more weed. Do you understand?
Yes, sir.
No alcohol.
And no alcohol. Okay. All right.
Judge, appreciate that.
All right.
Do you want to roll it to next week?
No. I'm just gonna, we'll just do 30 days.
Judge, I don't interrupt. We can go to next week. I can show up if he's excused from appearing and just get an update on the evidence, if that's what you're.
No update on the results.
Well, I want to know what the results are. I want to make sure that he's not using PCP. That's it. Or cocaine.
Judge, just procedurally, I would ask either one of the resolutions, either you approve the motion to withdraw or bring the defense up, because there's two attorneys of record now. She was removed, but like on deeds, the withdrawal was never signed, so it's just floating.
There's one sign, but what do you want to do?
I don't.
You want me to go ahead and grab
Yeah, that way, I mean, it's really fulfilling. So that's, I'm trying to make sure you get.
Pravella, I agree with you. Other, you know?
Yeah, I mean, whatever works, I know procedurally, like, I don't want that to be an issue.
Pardo, you're next. Don't go far.
Touch base with them, okay?
Okay.
I can keep checking with them, make sure whatever paperwork they have is correct.
Okay.
So if they need the correct address, whatever, make sure you do it, okay?
I know.
Have a seat real quick.
We're going. It's only 12:30. What are you talking about? Not 3:30. What? Oh, okay.
A lady.
All right. Oh,
I know.
what? Already? No. Yeah, so a lot of people are concerned about the last one. The VA, we have programs here that'll help VAs out, so he won't be left out in the dark, and we're gonna do everything to help him out. Did you hear come to visit us?
Yes, all the way from New Hampshire.
Come on up.
Colin sent me.
Very nice. We're happy to have you. Tell me how you are.
Oh, I'm doing pretty good. Come down, actually came down, combination of things, vacation, spread my wife's ashes, and come down to see the kids and you.
I'm sorry to hear about the ashes.
Yeah, I'm trying to remember when you were on Colin's channel, if that was before or after my wife passed. I couldn't remember.
I'm sorry to hear about that. I wish that it were, happier things.
Yeah, it's second wife in 10 years, so I'm kind of somewhat used to it.
How do you find Houston? Do you like it?
What's that?
How do you find Houston?
Hot and humid. Yeah.
And it only gets worse.
I know. My stepdaughter lives here. My stepson lives up by Dallas. But I retire in a few more years. I'll be moving down into this oven.
Really?
Yeah.
You really want to do that? So now you live in Michigan?
No, I live in New Hampshire.
New Hampshire. Well, the weather must be great over there. You have 4 seasons, right?
Oh, yeah. Yeah, well, 5 seasons if you include mud. Yeah, it is. It's a great statement. 50. I've spent my entire life either in New Hampshire or Wisconsin. I'm tired of the cold. I want
We don't got much of that here.
You
What's
don't.
that?
We don't got much of that here.
You don't have any of that here. When I went to law school, I went up there in the Midwest, up in Michigan, and I tell you, it was so cold.
Yeah.
And
Yeah.
me being from Houston, I'd never experienced something like that. So it was such a shock to me.
I warn people about that all the time. What a Wisconsin winter is like. And
Wisconsin's even just got.
yeah, you've never experienced anything until you experience 50 below weather.
I couldn't even imagine. So are you a cheesehead? No.
Oh, yeah, born and raised and will die a cheesehead.
Can I interest you in some candy while you're here?
I've heard all about that.
This is great stuff right here. That's one of my favorite. And here you can have some of this. Or here, let's give you this. This is good
Exactly
stuff.
what I want.
Here, I wish I had more to offer you, but I just don't.
I'm good right there.
Rachel, if you want some candy too, or guys, come help yourself,
I appreciate it.
No throwing. Yeah, we did that. We're happy to have you anytime. Come hang out with us. It's
Yeah, that's why I checked on it first and Colin was gonna text you when I was coming and Legal Fiction last night got a hold of Victoria and that I was gonna be coming in.
That's her. Look,
That could be you.
Yeah, Victoria.
Yeah.
famous Victoria.
Yeah, I was on Colin's channel last night and
He's great. I really like him.
yeah, he's awesome. I was on his channel last Friday night, in fact. I stayed at his house on the way out.
You stayed at his house?
I stayed at his house on last
Really?
Friday night.
You're that close to him.
Was that?
You're that close to where you've been to him. Wow.
Yeah, I stayed at his house and we did his live stream on his channel together. That was fun.
He has a lot of viewers.
Yeah, he does.
He's very popular and I find it entertaining and I watch him a lot too.
I'm a admin mod on about 25 different YouTube channels.
Really? Wow.
Collins is one of my regular ones. Kitchen Court Chats is another one. Credence and Mikey.
I watch all those too. Yeah.
Yeah.
And it's funny that, and I was telling Victoria and I and Melissa, we were having this conversation earlier where how things have certainly changed because before we started doing this where we aired everything and where we live streamed, none of us knew about this type of, I guess, existence or this type of life where the camaraderie of the people that you meet, and it's all over. It's just, it's so great, you know.
It is. I've made such a great family.
Yeah.
From YouTube, from
It's wonderful.
all this stuff.
You know, yesterday, you know, because every time we're done with court, I like to hop on and I like to chat with people who are watching, people from all over the world, with Scotland, UK, you know, Tokyo, just Australia, Australia, Denmark, Venus.
On Credus Biker, we got a lot of people from UK and a lot of people from Australia on there.
It's great, isn't it?
It's so fun. It reminds me back in the 90s when I first got online, and you had like AOL and Prodigy and all that in the chat groups, and that's what a lot of it reminds me of, and built up. In fact, that's how I met my first wife. It was in a chat group on Prodigy many years ago. And
it really is a great thing, and it's a cool thing how small this world is, and how just the friendships you make for one, not necessarily hobby, but one like this interest that you have in court channel watching, so to speak.
Right.
It's so great. And God, I mean, Victoria, just how many friends have you made? And just, you know,
So many.
how many enemies too, right?
More friends.
It seems like everywhere I go, even because I'm on a lot of channels of that, I'll go into pop in and check out another channel, and they already know me. Mayor Wrench McNolan. They know me on channels I haven't even been on. Plus, there's so many people that I know.
That's
and
great.
It really becomes a big family. When YouTube first started, you know, it was like small, almost like TikTok, small clips and stuff like that. And it's grown into such a huge entity and a life of its own.
Who's your favorite?
My favorite?
Besides Colin.
Court vibes.
Oh, my.
Kathy, court vibes. Court vibes.
Court Vibes.
Court Wise?
No, Court Vibes,
Oh,
the channel. Kathy with Court Vibes. We watch her a lot.
Yep.
Yeah.
She just,
She's a
well, the
court
thing,
cat.
she's a Plea though, right? She's at 4 a.m. She does her live stream and her channel. So
Check that one out.
yeah, it's great.
I don't think I've ever been on that one. There's so many channels, you know, gun tubers, you know.
Gun tubers, is that what you said?
Oh, yeah, like Demolition Ranch out here in San Antonio.
Never heard of it.
You never heard of it? He's the biggest gun tuber there is. He also has another channel called, well, he's had 2 other channels. There was Veterinary Ranch, or Demolition Ranch, which is his gun channel. And then Matt Carricker, which used to be called Off the Ranch. He's in the process, he's got the old Guadalupe resort, which closed down 20 years ago. Him and his wife bought it, and they're renovating it and bringing it back to life.
Huh, interesting.
Then there's Brendan Herrera, who's in San Antonio also, donut operator. There's gun tubers, and I also got all my car stuff, you know, Vice Grip Garage, Cletus McFarland.
You know, I had to say one of my favorite things that I've discovered that I like to watch also are the what's up to no good over there? What are you doing now?
You know, just a little cranky.
Ay, ay. I don't want to get I like watching how the sovereign citizens go around, and I really get a kick out of watching that, you know.
Do you ever get any of them in here?
Not much. I don't know why. It's not like Michigan gets like
Tons of them.
just every so often we'll get, but not much. And I don't know why. Maybe it's the demographic, it's the area, you know, big city.
The sovereign citizens are just,
I really get a kick out of like,
I had a cop pull me over and I go, hey, would it make any difference if I said if I was a sovereign citizen? And he goes, I'll give you 2 tickets. I go, well, I'm not a sovereign citizen.
yeah, that's great.
Yeah, I just, nothing, just a lot of history channels. There's one that I watch that's really kind of fun. It's called History in the Dark. And it's everything from trains to planes to, why a business went out of business. And he's the best trains ever made or the worst trains ever made. It's just kind of fun to watch.
I'll have to check it out. One that I've watched quite a bit lately is a guy called Team Skeptic.
What is it?
Team Skeptic.
Oh, yes.
I like watching that one a lot
Yeah.
too. I find
Team
him
Skeptic I watch.
in the Credence, and I like them, Mikey. But yeah, I guess I'll see you on there. You'll have to advise us which are other good ones as well to watch,
I'm just all over the place. I don't even have regular television at home anymore. All I do is watch YouTube. That's it.
Yeah.
It's more entertaining.
It is. It's great. And with your phone, and like what I do, I take it with me everywhere I go. I'm watching everywhere.
Oh, yeah.
I guess it's taken over.
When I'm at home.
You don't ever watch that stuff, do you? No.
When I'm
Do you watch TV at all? No.
most of the time I have it on the background noise.
So this is Stephen, by the way.
So a lot of times TV, any
It's
type of
mindless.
videos, it's just background noise.
I do that
While I'm
too.
doing other stuff most of the time I'm on creating documents.
Yeah.
Yeah, I get home for like Collins or any of the other ones that are live stream, Previous Mikey. I put it up on the big television and then sit there and do all my texting or all my chatting. But it keeps me out of trouble. That's the main thing.
You can always come here too. We'll keep you out of trouble as well. Just
I'll
come
be-
hang out with us.
Probably getting down here a little more often. Last time I was down here was 2 years ago. I came down to see the kids and of course eat lots of food.
This is great.
That's one of our main things. We travel not to see the sights, but to eat food.
Food's great here.
Yeah.
Barbecue, I mean, you can't go wrong.
Oh, yeah.
Not like in other places, but some of the Mexican restaurants here, the Tex-Mex.
Oh, yeah. Ojedo's Mexican restaurant up in Dallas is like our favorite up there. We got to go to Shipley's Donuts. We got to go to Whataburger. We got to go to Jack in the Box.
Yeah, that's right. Yeah, it's great. I love having you.
Yeah, I enjoy it. Plus, we got to hit all our Harley dealerships and get our poker chips.
That's all we need here, casinos. Yeah, casinos.
Yeah.
Fun.
YouTube kind of saved me. I had a year ago, I had surgery on my shoulder. I completely destroyed my shoulder. And that bunch of idiots that I hang around with on YouTube was what I needed. And then after my wife passed away last month, just everybody on there donating to the GoFundMe to help with final expenses and just outpouring of love has just been amazing.
It's a family, right?
It really is a big family, and I love being on there, and I love watching whatever. I usually watch you in a rerun.
Really?
Yeah, I'll watch you later on during the day or at night when I don't sleep because I very seldom.
We'll put him to sleep.
I very seldom sleep.
No, that's important. You need sleep.
Yeah, I ever since my first wife died, I've had insomnia, so I'm always cruising around watching anything, and I'll watch literally anything.
Yeah.
If it grabs my attention for 2 seconds and that, I'll watch it.
Yeah, I'm with you. I do the same thing. Are we done? What do you think?
Kevin needs to, Stryker needs to approach. And we need to.
Do we have any inmates back there?
Well, the Stryker has the last one, Mr. Williams.
And that out of county is supposed to get picked up in there. Well, they emailed me and said noon. It's already noon.
I mean, I'm gonna give him a PR bond because he's got to be out. We got to give them a deadline. Did they say?
Said noon today. And we
Are
still
we
have-
noon now? Yeah, it's noon. Are they here?
That's saying. They haven't called us asking for him, so maybe they're running late.
Oh, crap.
They said they'll pick him up today.
We got to get him down then. Can you send him down?
I'm gonna call him, see if I can get him that way.
Or should we give him a PR bond regardless?
What do you want to do?
Yeah, no, he's out today. He's been here at least 10 days, right?
We'll get him to fill out this either way.
We have a lot of people that come here, they get arrested in Harris County, but they're wanted from another county in Texas, like Bear County. They're wanted from Jefferson County, which is Beaumont. And the statute says that that county has 10 days to come get them. And if they don't, we have to release them. And so typically when they come to us, that's by the 10th day, because nobody's come, nobody said what they're going to do. So at that point, I usually give them a PR bond to let them out because I have to. It's the law.
Yeah.
And it doesn't matter what the charge is. It could be, we have,
Murder, it could be jaywalking.
and sometimes we've had cases that are really, really serious charges, and I still have to give them a PR bond because the county hasn't come to get them. But that's not, we call them, we notify them, hey, come get him. But they may not have the resources. They may not want to on a lowly.
It may not be worth their time.
Right. So our hope, and what I normally do is I tell them, hey, go back to where you wanted from, because if not, you're going to continue to get arrested. You're going to continue to sit here 10+ days every single time.
Yeah, go back, take care of it. And otherwise, you're just gonna get arrested, locked up, and then released and locked up and released. Yeah, just take care of it.
Mr. Stryker,
Yeah, Judge.
did you want to talk about anything?
I think we need this, Judge.
What's it? We're done?
Are you sure? Well, I just was gonna, I was asked to approach Judge on a older DWI case that I just got appointed to today.
Okay.
On
Actually, I'm gonna
Gerald Jones, Judge.
So much.
I don't interrupt.
Love having
If
you.
I'm still here on Monday, I might pop in again.
Come in, please. We'll be here.
All right.
We're here. We live here.
Thank you, Judge.
Well, ladies, gentlemen, it's been 2 hours that we've all been watching this together. Oh my Lord, that's amazing. I can't believe you all hung out with me for 2 hours to watch court. That's just craziness. You all should be commended and probably need help. I don't know any other kinder way to put that. I know I'm probably there with you. But it's another Saturday. It's been a good Saturday. I thought those were some excellent cases. I really enjoyed the conversation with the judge and the mayor there at the end. That stuff always is interesting to me. I'm great to I'm grateful when the judges are so kind to law tubers who come by visiting, because not only are we interested in watching this stuff on YouTube, but it is an interesting thing. I mean, it's a real life fact of life for all of us, at least in the United States, which is the judicial system that we all enjoy and live in and around and affects all of us. So every one of these cases is a learning case for all of us. And I think Judge Fleischer sees that. I think a lot of these judges, Judge Stevens and Judge Boyd, we've seen interviews from them where they express similar sentiments as far as that's concerned. So I'm always real happy to see those interactions. But more than anything else, I'm always happy to see somebody get 25 years for beating up on children that don't deserve it. That makes me even happier. And it makes me laugh a little bit when I hear about two brothers getting into a fight over a weed eater and one brother throwing a burrito at the other one. It also makes me a little hungry. So, ladies and gentlemen, it's lunchtime. Burritos for everybody. If you're anywhere around me, I'll buy you a burrito. Ladies and gentlemen, come back and see me next time. Saturdays, 11 a.m. Central, 12 p.m. Eastern Standard Time. I'll be doing some Judge Manning on Monday. at 7 p.m. Central Standard Time and 8 p.m. Eastern. And just throw this out there. Yes, Mom, if you want a burrito, I will definitely get you a burrito. Ladies and gentlemen, it's been a great show. Love you all very much. Stay tuned for Colin. Coming up next. I'll see you next time. I'm Lone Wolf. I'm your curator. And I am out of here.